So we are going live on Facebook. We're so excited to have you all here today. We're super excited to have Marcie Lipsitt here. If you don't know, I fangirl over her all the time. She's so amazing. She just says it like it is, and she talks about kiddos' rights as it relates to disabilities based on the law, the expectation of delivering on that law and protecting kiddos with disabilities. Marcie Lipsitt lives in Michigan with her son and 3 dogs. She was born feeling the ills, pains, and prejudice that plague children like her sister with severe learning disabilities, a father with bipolar disorder and OCD, and frankly, any child who appeared to have a challenge. She stood up for kids in school being made fun of, or those with few or no friends. Little did she realize that she was evolving advocacy and activism. For the past 25 years, she's been a mother to her greatest inspiration, her hero, her son, Andrew. Andrew has severe learning disabilities, including NLP, PDD, NOS, CAPD, and EFD. But in addition to that, he suffers from the childhood onset of bipolar disorder, OCD, ADHD, multiple anxiety disorders, and medical comorbidity. And so many other things. Marcie is the founder and co-chair of the Michigan Alliance for Special Education. And she's done so many things to rattle the world and the establishment of special education. And Marcie, we welcome you. Thank you so much for being on tonight.
Thank you for having me.
Yeah, so the floor is yours. I've followed you for a long time. Can you tell us a little bit about your background and how you came to be, as you said, the Lipsitt Special? How did you come to be in this space serving kiddos?
Really the way you sort of said it, Karen. My mother said when I was less than 10 that I had been born with a soapbox. And I used to be a little shy about it. I gave that up decades ago, but I was my younger sister's voice. And while I always say my parents had the money to pay for doctors and tutors, but the schools made a mess of my younger sister, who was just pre-federal and state special education laws and rules. And they really made a mess of her. At the same time, I was the one who fought for the kids that other kids were not being nice to, and kids that had disabilities. And by high school was lobbying for state and federal laws and rules. And then when my son was born, I was both an activist and an advocate, because my son demonstrated his special needs from the day he was born. And then I was his advocate and advocating for friends and family until in 2006, we took our school district in Michigan to a due process hearing. I never thought I'd be a parent in a due process. I say all the time, I was the latte bringing, cookie tray bringing, deli tray bringing, gift certificate giving, private paying parent. And it didn't bring Andrew a free appropriate public education. And we prevailed in that due process and set a precedent in Michigan. And at the same time, I uncovered some very, very dirty laundry in my school district's closet that made state and national news because of the impact of that. And then strangers started calling me, and I took a deep breath with the first one and listened and said, okay, I can help. I have for decades, just like you, Karen, webinars and reading, and people say, what's the last good book you read? And I said, what are you talking about? I mean, I live in the land of civil rights and special education. It's all I read. And then when the Council of Parent Attorneys and Advocates had their first special education advocacy training in 2012 and 13, and I was in that first cohort, which was so much fun. And William and Mary have their special education advocacy training and did their first group. We were the test pilot, and then they did a senior group. And really just any way of continuing to learn. You can't be an advocate without a willingness to learn every day. Sometimes you learn things you wish you never had to learn, but you're going to learn every single day about children, and sometimes it's a child with needs you've never served before. And if you're not willing to learn everything about that child, then you should not help that particular child. You can't be an advocate without being an activist. I refuse to work within poorly crafted, poorly funded, poorly implemented state and federal laws and rules without fighting to change them. And at the core of everything, I have believed in civil rights since I was very, very, very young. And when a parent calls, a new parent called tonight, and I said, Google my name, read about me. I won't be right for everyone. If you're looking for Gandhi, I'm not it. If you're looking for Martin Luther King, you are on my street. And I mean that very seriously.
Yes. Well, tell us a little bit about your sister.
So I have a sister who's not quite 4 years younger, and my sister was born anxious. I had this powder puff cutie pie baby sister who was born anxious and with severe ear infections that led to pretty significant auditory processing disorder and dyslexia, dyscalculia, dysgraphia, severe learning disabilities, and ADHD. And school was always hard for her. And because the schools were not designed to meet her needs, it really had a very adverse impact on her self-esteem. To this day, she has low self-esteem because of her years in school.
And what did they do to serve her, or if anything?
Very little. I'll never forget when she was in the second grade, and the principal didn't call my mother. He asked for me and my sister, because I was the older sister, to come into the office and asked my baby sister if she wanted to be held back a year. I'll never forget it.
Oh,
I'll never, ever, ever forget it. And my sister, who was sort of between the auditory processing and everything else, was always the who what kid because she wasn't following, and went, well, okay. So then they notified my parents that this is what they were doing and held my sister back in the second grade until early in the second grade. The teacher started saying to my sister, do you want to have lunch with your peers in the third grade? And my sister, of course, said yes. And then middle of the year, they moved my sister to the third grade. So my sister, who had missed half of third grade with severe learning disabilities, was pushed up to her regular grade.
so you have the same school district that Make It Up UCO Independent School District. That's what we have. Just make it up.
Make it up as you go along. And unfortunately, decades later, school districts are still making it up. I have believed in the institution of public education my entire life. I believe in John Adams and his words that you shouldn't go a quarter mile without a public school, and public schools should be publicly funded and not privately funded. That was 1783, and people just don't remember. Thurgood Marshall was one of my heroes. I mean, the Brown versus the Board of Education is what IDEA sits upon. But it's all very broken, and it didn't break itself. People have broken it from neglect. Americans stopped voting for public education in children 50 years ago. You can go back and read a famous report, A Nation at Risk, that was commissioned by former President Ronald Reagan. And while he commissioned it for the wrong reasons, it is a report that if you put your hand over the date, you think you're talking about today, because conditions are terrible. And I don't care where you live. In the most economically sound district, conditions are terrible for all children, between the shortages of teachers and the low standards for all children with IEPs. In Michigan, you can earn a diploma, and we're not the only state, but not all of them are like this. You can get a D- in every high school class and earn a diploma in Michigan. And the kids that I have that have learning disabilities or ADHD, but when they're in high school, I'm very clear with them. I would rather have you fail a class than get a D, because a D you pass and it's counterfeit, and the E you don't, and I can get you help.
Right.
So it's that very, very low bar of expectations that is plaguing all children right now in America. COVID fatigued parents who had kids home for over a year, too many are happy to have their kids just in school and don't realize they may not be with a licensed teacher.
Right. Or even licensed to drive a car, adult. Yeah.
It is the worst of times in America for public education. And I don't know what people expect when they complain about it. Did you vote for it? Who do you vote for? And voting is never enough. Do you call your legislators at the state and federal level? It's critically, critically important. When I speak publicly, I tell people get out a pencil and write down 202-224-3121. That is the US Capitol operator. Get to know that number and reach out to your members of the House and Senate. Tell them they have to care about public education.
Right. When you talk about grades, I always say now everybody's grade is fraudulent. I have a family that I serve, and her son has learning disabilities, and he came home and said, "Mom, if we get an 80 or below, they make us retest." What? Get an 80 or below. So I say, if your kid's valedictorian, or I don't believe your grades. Now nobody fails, and we test them 87 times, which is not learning,
Yes.
right? So who knows if anybody knows anything? The pressure on these teachers to pass state testing. We sure fund state testing. That's a whole nother sermon. But I don't want to graduate kids. I want to educate kids. And we're so busy with the 4x4x4x4 graduation plan. Whatever happened to what do you like to do? What do you not like to do? We're so busy getting them out of high school. We're not getting them ready for adulthood.
No, we're not. And I want every child who can to go on to the best possible adulthood. We're not preparing kids for that. I say all the time, I can sleep at night with a child who graduates high school and is reading at an end of 8th grade level, because that's solid community college. I can't sleep at night with a kid given a counterfeit diploma who's reading at a 3rd grade level. And there are so many of those kids. When the US Department of Ed Office of Special Ed puts out their annual report and you look at graduation rates, what a counterfeit, convoluted number that is, because that's a number that needs to be dissected. If we dissected the diplomas that kids are earning, I would like to think many people would be shocked
Right.
at the low level of skills that so many children have.
Right. Absolutely. So tell us about using the instrument that is the Office of Civil Rights, U.S. Department of Education. It's one of the last things that I learned, and of course, like you said, we're always learning in advocacy, is a dispute resolution option. Can you share with us when that's appropriate to use that instrument and when it's not?
Yeah, I'm always happy to talk civil rights.
Yeah.
My dream is that we'll fight for civil rights to be funded, because that's one of the problems, that our 2 federal civil rights laws, Section 504 of the Rehabilitation Act and the Americans with Disabilities Act, receive no federal money. So you look at the Federal Office for Civil Rights, they've always been underfunded and understaffed. School districts get no money for children who are on 504 plans. They do for kids that have IEPs, or if you're in certain states like Texas, and ARD. But it is still my favorite topic, because it is so misunderstood, underutilized, and undervalued. I have countless people who don't understand that a child that has an IEP is protected not only under the Individuals with Disabilities Education Act, but also under Section 504 of the Rehabilitation Act and the Americans with Disabilities Act. And they're all different. You can file a federal civil rights complaint or a special education state complaint if your child has an individualized education program, an IEP, and a supplementary aid, also called an accommodation, is not provided. And if a child has, I'll exaggerate, 100 accommodations in an IEP, and one isn't provided by one of 6 teachers for a child in middle school or high school, that is a solid federal civil rights complaint. These are administrative, they're not lawsuits, which is also so misunderstood. And I say to people, I am not an attorney. The school district lawyers try to get me all the time. I don't cross that line, and I drive them crazy, because filing civil rights complaints, like state complaints, is an administrative action, and it is not the unauthorized practice of law. Anyone of any age, a 6-year-old could file a federal civil rights complaint. I mean, there's no law on the age that you can begin filing these. I started filing federal civil rights complaints in Michigan largely because our Michigan Department of Ed, that I called the Michigan Department of No Education, and our Office of Unspecial Education, and I refer to our state director, Terry Rink, as the Grinch who stole a free appropriate public education, that they don't award compensatory. And if they do, it's minimal. And even when they find violations, they wouldn't find a goal not measurable with the GPS navigation system. I mean, they just are so morally, ethically bankrupt, and they know I feel that way. I write about them on Facebook all the time. So I started helping families with federal civil rights complaints anytime an IEP isn't implemented. And that is the key point. A failure to implement an IEP, so a failure to implement a speech and language service, an occupational therapy, a physical therapy, orientation mobility, a visual impairment service, a hearing impairment service, physical therapy, or a failure to provide a supplementary aid, an accommodation, a failure to, a child has documented extended school year and the district doesn't provide extended school year. The child has resource room hours or academic skills hours. Different states refer to them differently, but special education program time. You can file a federal civil rights complaint on any aspect of an IEP that is not implemented. You can file a civil rights complaint. I helped a mother earlier today. A district ignored the timeline to evaluate for an IEP. So if you submit a written request and you don't want to ever do it verbally, you want to do it in writing.
Can you do it verbally? Can you just stand outside the office in Dallas and go, I know you're in there?
You know, I think of Pete Wrightslaw, who is one of my forever heroes. And Pete's famous quote, if it wasn't written, it wasn't said. If it wasn't written, it didn't happen. So yes, you want it in writing. The Office of Civil Rights will recognize an email. Some state departments won't, which is wrong. But I just tell everyone, be safe. Put it on any kind of Word doc, date it, sign it, and fax or drop it off or scan and email it. And if a district ignores a request for a special education evaluation, for a 504 evaluation, or you have an IEP and they ignore your request for a new evaluation, including a functional behavior analysis, you can file a federal civil rights complaint. I do them electronically. If you go to United States Department of Education, Office for Civil Rights, online complaint, it pops up immediately. You cannot miss it. And you click on it, and then it takes you through prompts. You can fill it out in a PDF form, or you can use their electronic. I've never used the PDF because it's so easy to do the electronic. And the only thing you have to do once you hit the submit button, and you know if you made an error because they won't accept the complaint, they'll tell you what you didn't fill out. Sometimes people forget to fill in a date, or they've gone back further. You can only go back 180 days, and some people will make a mistake on timelines. Once you submit, the only thing you have to do, and you're given an email with a link, is print a one-page consent form and fill in your name and your school district's name, and you sign and date that they can use your name to investigate. And then you scan an email and they give you the email address. When I do it for families, I email all of that. I mean, I say, you know, you have to fill in your name and fill in your school district and sign and date, and then scan an email. And I'm Cleveland, so it's ocr.cleveland@ed.gov. I help Denver families, it's ocr.denver@ed.gov. There are 12 regional offices. The negative for the civil rights complaints is only that there is not a formal timeline to open or to investigate. And while they have been faster the last 2 years, and I've seen them for a while, it's still slower than a special education state complaint. State complaints must be investigated and a report issued within 60 days. That is not true with the Federal Office for Civil Rights. But you will get more out of a civil rights complaint if it's open for investigation. If you file, your school district doesn't know you filed it until the Office for Civil Rights opens it for investigation, and then you and your school district are notified the same day in an email. So if for some reason the Office of Civil Rights doesn't think they have the evidence and doesn't open it, I always say no harm, no foul, because your district has no idea you filed it.
Right. I love getting that letter with the big tree on it.
I do. People also have to either remember or learn that not only can you file on a failure to implement an IEP or a 504 plan, I have successfully filed on buildings that are not accessible. I have filed on parking lots that are not accessible. and on playgrounds and on websites, and been responsible for building reconstruction and parking lot reconstruction and playground reconstruction, and a whole lot of websites that have had to go through a lot of reconstruction to be barrier free. So for people that don't have access, it's a very, 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 very important tool. The other important piece to remember is that if your child has an IEP and you decide you don't want that IEP, that you don't want your child in special education, and at times there are reasons for that, you can withdraw your consent, and then a special ed administrator will say to you, well, don't think you're getting a 504 now, because you can't have a 504 plan because you turned down the IEP. And that is the reality because of some bad policy out of the U.S. Department of Ed Office of Civil Rights. However, what is in place and can be used beautifully is the Americans with Disabilities Act, which is what is used in a lot of the colleges, and an accommodation plan. So while it's not technically called a 504 plan, on school letterhead, it is an accommodation plan, and you can have all the same accommodations that you would have in an IEP or a 504. And if a district fails to provide something, you can also file a federal civil rights complaint.
Right. Let me ask you about the accessibility. So I'm always shocked to find businesses, government buildings that aren't accessible. Since I don't have any trouble walking into a building with a ramp or without a ramp or stairs, do I have to find somebody before I can file on their behalf, or can I just file as somebody that lives here and this building's not accessible?
You can file as somebody that it just lives here on behalf of people, that, as long as you're not naming an individual. If you name an individual, that individual has to sign the release. But as I've done a bunch of times, I'm filing for a group of individuals.
Okay, so they don't necessarily have to have, if they take federal funds, they have to abide by all the requirements, correct?
They do. I have filed a lot of complaints that don't involve a person.
Okay, and so if you, so when you ask for that, and obviously same thing, whether it's state due process, mediation, or OCR, they're asking for these things, right? What's the problem? What's the supporting facts? And what's the resolution? So the resolution for an OCR complaint is that I'm wanting the building to have a ramp. Do I have to give them that specificity, or do I just say that it's appropriately accessible for individuals with disabilities?
You have to include a resolution.
Okay.
They don't have to go with your resolution. And sometimes you can expand upon that. You have to include a resolution. So I will typically, if it's a failure to provide special education programs or services or accommodations, whether it's an IEP or a 504 or just an ADA plan, is compensatory services for a child, depending on what does that child need. If it's a building access, I want the building brought into compliance. I want it barrier free. I want it accessible. If it's a parking lot, I want that parking lot made accessible. If it's a playground, I have our wealthiest school district in Michigan. All their playgrounds have to be accessible because of a complaint that I filed against one of their elementaries. It took a while, but they have to maintain accessible playgrounds. And an accessible playground isn't just a swing. I had a district try to pull that one time.
I mean, a little ramp, a little tiny ramp over. Yeah. Yeah.
If it's a website, they have to remove all the barriers. It has to be barrier free for individuals that are blind or low vision, deaf or hard of hearing, have fine motor impairments, have any kind of physical impairment, have a cognitive impairment. There are people with ADHD that struggle with websites. So it has to be barrier free.
Okay. And maybe not where you live, but we're big in Texas. And so our schools have a school, and it gives birth to 50 little, these little, they're not trailers, but these little, what are they? We build onto the school, right? They're these little houses, and they just have a little steps up to them. They're not accessible. Would those be considered still part of the school?
Oh, certainly.
Okay.
If they're run by the public school, they have to be. In fact, so do extracurricular activities. I've helped I had one student, we filed a really good civil rights complaint a couple of years ago, who has type 1 diabetes, and they didn't want to provide a refrigerator at outdoor sporting events for his insulin. That didn't go over real well with the Office for Civil Rights.
Oh, yeah.
So there are times I've had, every once in a while, I mean, at least a dozen times, I have had a special ed administrator call me personally to file a federal civil rights complaint, because they're not, shame on them for not being comfortable doing it themselves, but they're not, but they want to get something taken care of, and they know that I will do that. So anyone can file on behalf of a group.
Portables, they're called portables. Thank you, Karen.
Yes.
So the schools
they
have
were on the
portables. So
ground.
I go to, Elm High School and there's 17 portables, which means my kid can't take that class. So do I just file, this is my name, Elm High School? You can't access all of the classroom locations. Is that what you put?
It is. I mean, I cite the laws. I cite Section 504 and ADA. And then I say that this group of people who have physical impairments cannot access these buildings, and I describe why. If I can, I take a picture. Pictures go a long way.
Okay. And I know just from the little bit that I file, of course, you are the professional filer. When we send that first thing, they always say in the thing, don't send anything. Are you saying if I know that it's a building they can't get into, just go ahead and send some pictures with my complaint, or wait till that investigator reaches out?
No, I send, if I have very strong evidence, I tell people send it with the consent. When you scan and email the consent, send your evidence.
Okay, perfect. And so when that happens, what can a parent expect? So they've done their, they filed electronically, they sent the consent. And I know I've had them call 8 months later, and I've had them call in 2 hours. I'm like,
Yeah.
oh, I'm ready for this. I'm not ready for the blind date. So what should a parent expect?
No, I tell parents, watch your email and watch your phones. You don't know if an attorney from your regional office will reach out in 2 days or 2 weeks or 2 months. What I do with my families, I tell them, give it 3.5 weeks, not a month. If you have not heard from an attorney in the Cleveland office, I give them the supervisor, Brenda Redmond's email address, and tell them to email her and say, I filed this complaint, I submitted the consent, it's been close to a month, can you tell me who has my complaint? And she'll respond with the name of that attorney. And sometimes you can push your complaint up in the pile. So it's not wrong to do that, because some are, I helped a mother in Denver file one a couple of weeks ago, and literally 2 days later, we had an email from the attorney in that office saying, I want to set up an interview. So you will hear from an attorney in your regional office, and you definitely have to watch your email, because if they email and you don't respond, they will close that complaint. If they don't hear from you in 14 days, they will close it. So that's very important. They will schedule an interview to go over your complaint with you. Sometimes those are very, very short. Sometimes they're longer, depending on the scope of the complaint. And I always tell people, remember that the majority of civil rights attorneys, there are a few bad apples out there, but the majority of them are really the good guys there to enforce federal civil rights laws. And they're not, most of them are attorneys. They don't represent the parent. They don't represent the district. Many of them are not shy, like the one that I did an interview with today with a parent. When they're outraged by a district, they're not shy about it. But they're also not in charge of deciding exactly what happens. So first you have the attorney or two attorneys that evaluate your complaint for the sufficiency. And then it can take anywhere from a week to a couple of months to receive an email and a written notice attached that your complaint, all or in part, has been open for investigation. And you can have 4 different allegations, and they open 3 of 4, or 2 of 4, or 1 of 4. If they open anything, it is a win. And because when they notify your school district and they ask your school district for written documentation, I tell people it's like a crash landing in the backyard of that school district. The Office of Civil Rights can make a school district miserable. They can come in and do interviews and phone calls and demand thousands of pages of documentation.
Right. I love when people tell me I'm wrong, because it's so enjoyable. That is not true. You don't have to document accommodations. And I always say, if I told the IRS that I had $30,000 in cash this year, they would ask for what? Receipts. So as I heard your first podcast years ago when I was writing feverishly, can you kind of give us an idea of what that investigator might say to the school, or are they just sending them a letter? What are they asking for as evidence to either prove their position or disprove your allegation?
Yeah, when they notify the district, their notification includes a request for documentation. And that
Oh,
documentation can be all the students' records. It can be documentation for all the students with 504 plans. I mean, they can ask for as much or as little as they want. And when I file systemic, I have a class action open right now for 733 kids in one of our school districts. And for me, that's fun. I mean, that's the fun part of what I do. I'm helping a lot of kids that I have never met. I have one for 98 kids in a Colorado school district. That is a lot of documentation and time and effort. Some school districts, the Office for Civil Rights can ask a parent and ask a school district, are you interested in entering facilitated resolution between parties? And I always tell parents that if your district wants to do that, you should absolutely do that.
right.
Because that is a formal mediation that is scheduled. The attorney that is investigating your complaint is not the attorney that mediates. That is a different attorney, because if you're not successful and it goes back to the investigation, the investigative team doesn't know what happened in mediation. It is all, you're signing a privacy statement that you will not share what went on. But if you can reach agreement in a mediation, one, it's the fastest way to achieve your goals. And it's a lot faster than letting the Office for Civil Rights investigate. I've had investigations that have gone 1 to 4 years.
Right.
And I always say justice delayed is justice denied.
Right.
Often what happens if you get a nasty school district, and there are thousands of them in America, they will let it drag out, knowing that they will enter into a resolution agreement with the Federal Office for Civil Rights, and then the Office of Civil Rights will require the school district to schedule an IEP team meeting or a 504 meeting with the parent to craft a compensatory education plan. And it's not a get out of jail free card for a school district, because they can't come to that meeting and say, well, there's no loss, we're not providing anything, because they have to submit that compensatory plan back to the Office for Civil Rights. So do you end up getting services out of civil rights complaints when there's a need for services? You do. It just depends how quickly you get them.
Right. So what would and I actually had a hearing, not a hearing officer, a federal investigator sort of prompt me to do it, but I didn't know how to do it. What warrants, I mean, obviously you're not sitting at the car pickup line, hey, honk, if you feel like your civil rights have been violated. How does one, if we have a timeline of 180 days, how do you find and file a class action?
Well, in the case of the class action that I filed, I didn't know there were 733 kids in the district. I didn't know that until the attorney from the Office of Civil Rights shared that with me.
Okay.
I only knew that the rights of all of the children with IEPs had been violated the first week of school, a year ago, September. I tried with COVID. It's so hard to keep everything straight.
Right.
And I knew that their rights had been violated. So I filed a complaint, and I had written documentation of what the district had done. I had them, I had all the proof I needed to file that complaint, and not knowing there were 733 kids involved.
Okay, but you didn't have to say this is a class action suit. You just made the allegation, correct?
It was systemic. I made it on behalf of a group of people. It's
Okay.
like when it's the same thing when I file on a building or on a website or on a playground, that it is a group of individuals. And sometimes I know how many, and sometimes I don't.
Okay. And that's just the language you use, just a group of individuals.
Well, you have to check off when you're going through the prompts and you're filing electronically. You have to say, are you filing for yourself? Are you filing for an individual? Are you filing for a group of individuals?
Right, but you don't have to list the 786 little cherubs that were involved.
I do not. No.
Okay. And then somebody just asked in the chat, which is a great question. So the timeline for a class action it's the same, or It's still the 180 days.
180 days, whether it's one person or it's a group of people, and you can appeal that timeline. I don't suggest it. I have never seen the federal office extend a timeline ever.
Like if you were abducted, maybe they would do it, right?
I don't know what it would take for them to extend a timeline.
Right.
So, I just tell people I will sometimes provide some historical information just to really hit home how bad these violations are, because being an advocate, I see terrible things every week.
Yes.
Every week I see, sometimes it's a new terrible, but I see terrible every single week.
I think you said to me last week, worse than bad is still bad, right?
Worse than bad is still bad. I mean, being bad, the difference between bad and terrible is indistinguishable. I mean, it's just bad is bad.
Right. So we talked about before, and I had followed you. You had filed a couple. We'll go with the word couple. You have the real number of web access allegations. Can you tell us about that?
So in February 2014, trying, and I was successful. That's the good news. Trying to stop our Michigan Department of No Education from slamming through a devastating package of proposed revisions to our Michigan administrative rules for special education. I mean, insane package. And they were doing it in their own style. They released the package for public comment on the Friday of a February break. So instead of a month, most people had 3 weeks. And they outsmarted themselves when they created a new way of submitting public comment. They took away the right to drop it off or fax it and or email it. And you had to either send it to a P.O. box. So thousands of people could have sent it to a P.O. box and, okay, we didn't get these. And who would be able to prove them right or wrong? Or you had to fill out this new online system that was not field tested. And they were taking their stupid pills when they created this form to fill out public comment. I said with humor, you could be Barack Obama or Mickey Mouse and fill it out, because it was 2014. And lo and behold, because I did a FOIA for all of the public comments submitted, somebody filled one out for Luke Skywalker. And I just laughed. But it was such a flawed system. But on top of it, the web page for this package, and I knew nothing about web accessibility in February 2014. I knew nothing. I had never filed a web access complaint. I didn't know about doing, using, there are you can use online web access checkers. You can do manual checks of a website. I didn't know anything about web access. What I did know, as the granddaughter of a grandmother who lost her hearing as an adult, was that the videos were not closed captioned. And my son with dyslexia was struggling to read some of the font. So this was on Friday the 14th. And on that Monday, I filed my very first federal civil rights web access complaint. And I literally said, I have reason to suspect the Michigan Department of Education Office for Special Education webpage pursuant to this rules package, and I included a link, is inaccessible for individuals with who are deaf, hard of hearing, and low vision. And 2 weeks later, I was at the Council of Parent Attorneys and Advocates annual conference in Baltimore, and I had the privilege of presenting on filing state complaints with one of my heroes, Candace Cordiella from the Advocacy Institute. And I got a phone call, and I know the Cleveland number. It's area 216-522. I knew it from helping families with complaints. And it was two attorneys, Sarah Poppleton and Ann Millette, who said to me immediately, "We're calling to tell you we're opening your complaint." And it was like, it's not my birthday. And they wanted me to know that based on the nature of the complaint, they were going to expedite it. Well, it wasn't exactly expedited. They didn't issue the final report where they found Michigan in formal violation of Section 504 in the ADA until June of 2015. However, what they did when they opened it was they gave me all the paperwork and leverage I needed to make a lot of noise about this flawed public comment period and what the MDE was trying to do. And the package of rules itself It led to Michigan has a joint committee for administrative rules. So when any department of government wants to pursue rules, it goes through this committee. Usually it's just a rubber stamp. Well, it wasn't
Right.
a rubber stamp because I had developed relationships with the chairs of that committee and went to them immediately and spent hours educating them on why this package would devastate our children with disabilities, why the public comment period was so disingenuous, and the fact that on top of everything, the website wasn't even accessible.
Right.
They held the first ever formal hearing on the rules. And our lieutenant governor, who has a child with autism, spoke at that hearing. I got him involved. And I'll never forget the Senate chair of the committee, Senator Papa George, who said, I don't need to hear from anybody else. We are not putting this package through. And the Michigan Department of Ed was in shock. I mean, they were really shell-shocked. They were sure they were going to slam that package through. So between that and between the website being found then in violation in June 2015, and they had to take down 9,400 documents to make them barrier-free. They had to close caption 840. They had to do training on how to create barrier-free web pages and content that ended up going through the entire Michigan.gov and every single department. Between that complaint in 2014 and 2015, I filed about a dozen more. So when a school district or one of our intermediate school districts ticked me off, I checked the website. And I learned from one of the attorneys out of the Cleveland regional office about automated web checkers. He said to me in a conversation a few months after I had filed that complaint, he said, you have no idea what you did with that web access. And he was right, I didn't. He said, and I shouldn't tell you this, we use PowerMapper. And I said, what's PowerMapper? Well, he turned me into a monster because PowerMapper is an automated web checker. And then I learned about A-Checker, which actually they've gone out of business. And then another attorney in the Office for Civil Rights taught me how to do a manual check of a website. So, you know, the whole web access evolved between between January 2016 and March 2018. I filed just over 2,400. I filed them against 48 state educational agencies. Only 2 were accessible, Minnesota and Virginia. However, the state schools for the deaf and blind in Minnesota and Virginia were not accessible. I filed against the Puerto Rico Department of Ed and Guam and the Commonwealth of the Mariana Islands and the Virgin Islands.
Didn't you say that you filed with something with Perkins?
The Perkins School for the Blind. I mean, some of it to me was shock and awe.
How can that not be accessible?
For the blind? How can the American Printing House for the Blind have an inaccessible website? How can Bookshare, so anyone that knows about Bookshare or Learning Ally that provide audio and digital text to students, had inaccessible websites. In fact, I took so much heat on Facebook because of my Learning Ally complaint. Someone high up from Learning Ally said, you're just wrong and you made this up. Well, I posted the notice opening it and said, here you go. You think the OCR just opens this for no reason? It was shocking to me, some of the various entities that I found. In fact, the US Department of Ed Office of Special Ed website was not accessible. And while I couldn't file against them because they're federal, because of all the noise I made, their website is accessible. And it's led to a lot of things. You know, Senate offices have been working to make their US Senate offices make their websites barrier-free because of my work on web accessibility and my relationship with some of those legislative offices and their staff. So I filed all of these complaints. And in my spare time, my husband would come upstairs at night at 10 o'clock and say, get off your iPad. And I mean, I was, you know, I am an advocate during the day and I'm buried in special ed meetings, but on nights and weekends, I was filing and I filed over 2,400. At this point, I filed over 2,600. And I filed against colleges and universities and public libraries. And I filed against parent training information centers, which made some people really, really angry. I filed against some really major public libraries, Boston and Philadelphia and Seattle and Detroit. Nobody was free from one of my complaints if I learned that the website was inaccessible.
And so can parents just go do that? Like they can log off and file tonight about their
Well,
school?
they can't. So let's now go to what happened as a result of my filing all those complaints. I really upset the former education secretary, Betsy Cruella de Vos. And this woman who explodes my vilometer, and she did before she was the ed secretary, has a charter school in Western Michigan Aviation Academy. Well, I checked her website and it was not accessible. She wasn't real happy that before she was ed secretary, I filed a complaint that was opened for investigation. And March 5th, 2018, and it was done so covertly. There was no notice in the Federal Register. They overhauled the case processing manual that is used by the Federal Office of Civil Rights to evaluate, open, investigate, and resolve complaints. And they created a rule that immediately people started, attorneys helping families and attorneys representing school districts were calling it the Marcie Lipsitt rule. They created a rule to shut down my web accessibility work. They created section 108T, which I called 108T for terrible, that gave the office's license to not open, and in my case, dismiss 1,000 previously open investigations and that had not yet reached resolution, although as it turned out, 66 had reached resolution and they still dismissed them because the letters hadn't gone out. But they could dismiss any complaint filed by for an individual or for a group on the same issue. So even though I investigated every single website, I didn't rubber stamp them, I didn't write the same complaint for 2,600, it didn't matter because it was on the same issue. It was on website accessibility, which is insane. And between March 5th, 2018 and March 25th, I was receiving anywhere in one letter from 1 to 120 dismissals almost every day. I mean, it was, I suffer from depression. You don't have to suffer from depression to be depressed. But I also had to figure out what to do about it. And I went to work, which is what I always do. I reached out to the Council of Parent Attorneys and Advocates. I reached out to senior congressional offices and staff that I've gotten to know over decades that I thought would care. And I went to Candace Cordial at the Advocacy Institute. And on June 1st, the Council of Parent Attorneys and Advocates and the National Federation for the Blind and the NAACP filed a lawsuit against Betsy DeVos and US Ed over what they did with creating those rules and dismissing all of those meritorious complaints. The US Department of Ed Office for Civil Rights settled that lawsuit in February 2019. I knew in November 2018 because the attorneys were keeping me in the loop since I was the majority of the evidence for the lawsuit. And I got a letter from the US Department of Ed. It was close to Thanksgiving that said, as you know, we have again revised the case processing manual and removed section 108T, and we are reopening your, I think it was 972 previously dismissed complaints as directed investigations. And while that sounds wonderful when you hear it, it wasn't, because a complaint opened as a directed investigation, the person who filed the complaint loses all control. So I had no control or appeal rights over those 972 reopened investigations. And the Office for Civil Rights has played so many vile games with my directed investigations that I then reached out to the US Department of Ed Office of Inspector General. And they opened one investigation that led to a pretty scathing report last fall, but it wasn't scathing enough. And their investigation had stopped, but I continued to send information. So the day that report was issued, they had already opened a second investigation into how the Federal Office for Civil Rights has been handling these complaints, because they won't even investigate one now. They won't even evaluate it. I mean, if I tested them last April, so almost a year ago, and in 14 days, I filed 214 new complaints, and they won't even evaluate them. So until the Office of Inspector General comes out with their report, which could be months to another year, or Catherine and the Assistant Secretary, Catherine Lehman, revises the case processing manual, you're wasting your time trying to file a web access complaint right now. All you can do is use your voice on social media and reaching out to your legislators and saying to them, do you know that the Federal Office for Civil Rights will not open a web access complaint? There are no civil rights for people that can't access a federally funded website right now.
Right. And it has to be federally funded. Several people in the chat have said about, what if, not, I mean, just making it, McDonald's had an app. That app wouldn't have to be accessible because they don't accept federal funds. Is that accurate?
Well, I filed against private colleges that they still have to be accessible under the Americans with Disabilities Act, not under Section 504, but under the Americans with Disabilities Act. So people don't think of, if you're looking at a K-12 parochial school, you can't file a civil rights complaint because they don't take federal funds. That is not true at the college level, because some of the most expensive, most famous, most heralded private colleges and universities, they take a lot of federal funds because of Pell Grants, because of all kinds of federal grants. So I had a really good time. No religion was saved from one of my complaints. I'm Jewish. I filed against any college or university and I filed against about 1,000.
Okay. And so when you're looking at a school district or you have a parent, a lot of my parents already feel retaliated against just asking for an evaluation. Do you find, and I share with my parents, it's not been my experience until recently, that when you file that there's retaliation against the child, might be against the parents, do you find that there is that same sort of, I don't want to say courtesy, but that protection when you file OCR?
I have not personally had a family that I am assisting retaliated against for filing a civil rights complaint. If anything, I find that the child is better taken care of, because most districts don't want more than one, although I had one district we filed for, and I mean, ended up getting a student like 700 hours of comp ed over 4 complaints. I have not had a family face that retaliation. I tell a family, what worse retaliation is there than watching your child lose his or her education? To me, there's no worse retaliation. If your child is not learning, if your child's not receiving meaningful educational benefit and a free, appropriate public education, that is the worst form of retaliation. And I will never, I tell people I am unapologetic in my advocacy. I will never apologize for filing complaints. I have very good relationships with school districts that I file complaints, whether I file it directly or I assist a family. I still maintain very respectful relationships with the majority. Districts that I don't have that kind of relationship, it's not because of a complaint. It's because they're just a vile school district and they would be awful with or without a complaint. If anything, those are districts that need more complaints filed.
Right. I have a district that I filed that they opened it. The letter to open it was October 21st, 2021. And then I haven't heard anything. So what's happening? It's one of my pretty standard complaints. You didn't implement the IEP by delivering the accommodations, and it's just been radio silence. So what's going on during that
families time? Sometimes it's sitting in a pile because they are so underfunded and understaffed. Okay. I tell parents, stay in contact, and the attorney will tell you that. Reach out to me. Reach out to me anytime. I tell parents that have open complaints to send an email every month. What is happening with my complaint?
It doesn't mean the school's like negotiating with the OCR.
Well, sometimes the school district is negotiating with the OCR. And then you end up with a Section 302 resolution where the district goes into resolution with the OCR. And that's when parents end up ultimately going to an IEPT meeting or a 504 meeting to craft a comp ed plan.
Right. And I'm nowhere near you, but I mean, except for the ones that have not been opened, I've always had at the end, the parent has been offered, or the school district work with the parent to bring resolution. So if for some reason I got really close one time and I was just kind of exciting that it might actually happen, the investigator said, well, we could just depose all of the people that are part of the allegation. I was like, oh, that sounds fantastic to me. But I guess once they offered that to the school, they weren't really interested in all their staff members answering questions to a federal attorney. Is that accurate?
Yes, they all use their attorneys for those civil rights complaints.
Okay. And have you ever had cases where the school district said, no, we're not going to settle with Marcie and her family, and then the federal government deposes those school-based members?
No, what they end up doing is they will, and it's only happened a couple of times, they will issue a final report. They will find the district in violation of Section 504 of the ADA, and they will order the district to do something. That doesn't happen very often. The majority of time, either we go to that facilitated resolution, and most of those are successful. I have a few that aren't, and then it just goes back to the investigation phase. And ultimately, sometimes we still end up at an IEP looking at comp ed, or the OCR tells them what they have to do. But I haven't, and I've only had a couple along the way. I had one on bullying for a family, and I tell families, bullying is a hard one. You've got to have really solid proof for bullying. I had a bullying one that wasn't opened. The majority of the complaints, if I suggest to a family that they should file a civil rights complaint, it's because I am 100% sure it's going to be opened. There is no question mark about it. If I don't think they have a good complaint, I'm very clear with parents. Lately, as bad as conditions are, if a child has an IEP, or where you live, if you live in the land of an ARD like Texas, and you have portions of an IEP that are really poorly crafted, you have a present level of performance, or in Michigan, it's a present level of academic achievement and functional performance that has no baseline data at all. I mean, there is absolutely nothing in it, and the goals aren't measurable. Even though I know how bad our Michigan Department of No Ed is, if I have a family that's in a really bad place, I will help them file a special ed state complaint and a federal civil rights complaint. So I will carve out the accommodations that aren't implemented, or services that are not implemented, in a civil rights complaint. And I'll carve out sort of the meat and potatoes that don't drive comp ed in a state complaint, because a state complaint, you have to give a copy to your school district. So
Right.
when a state complaint is filed, your school district knows about it the day you file it. They don't know about the Office of Civil Rights. And because of my efforts with the US Department of Ed and Michigan, and making Michigan miserable often enough, Michigan makes our school districts miserable in state complaint investigations. So while they're bad at awarding comp ed, they're great at making districts pretty miserable. So more districts than had ever before are asking families if they want to go to mediation on a state complaint. And then there's a double whammy, because you go to mediation on a state complaint, but they don't know there was a civil rights complaint filed.
Right.
So for a child that really needs a lot of comp ed, it's a way to get a lot done.
And so what do you say to families that say, oh, I don't, I feel bad, or that only one person did that? I have a lot of, I call it buyer's remorse, but I think what you said was profound. Having your child lose his education, there's not a greater, you feeling bad doesn't prepare your child to be an adult.
It doesn't. And I tell parents when I'm meeting, especially with new parents, and sometimes it's not new parents, it's parents that have been struggling for a while. A good advocate not only fights for the rights of a child and protects the rights of parents, a good advocate is a teacher. And the information that I give to parents, what they do with that information is their decision.
Right.
And parents have to be ready to file any kind of complaint. And some parents will never be ready. And other parents are immediately ready. And some parents are ready, but not immediately, just a little later in the game or in the process. And as advocates, we have to meet parents where they are. In my perfect world, everybody would go to the mat to fight for a child. I do what I do for a simple reason. Not one person asks to be born. I mean, not one child is given a choice before that child is conceived and plopped on this planet. Children are born, and they deserve every tool and environment that we can give each and every one to live the best quality of life. I have children that have severe multiple impairments. I have children that have severe cognitive impairments. I want every child to reach that child's potential and have the best quality of life. And no one knows what that is until you educate that child the best that you can.
Right. Absolutely. Such good information. Somebody on here said, my son has a vision impairment. Does that mean that he has to be able to access his school curriculum online? So now
That would
almost
be a
everything
yes.
is.
That's a complaint waiting to be filed, just like a student that is deaf or hard of hearing and didn't have Zoom. That was a great complaint over the school closure that I wrote all about repeatedly on Facebook and on Twitter, and saying, folks, if your kids don't have closed captioning, file a complaint, because so many districts got away with not having accessible instruction during those school closures, and those school closures were terrible. The
Right.
majority of children can't learn that way.
So, and that's different than you just said, don't follow web access right now, but this is just about Billy Smith. He watches he listens to a video because he has a vision impairment, but there's no closed captions.
Yes, if it is for an individual child who didn't have access, you can file a successful complaint. I have 2 open right now about Zoom.
Okay, it doesn't matter if they're in a complaint with the state for other issues.
It has to be other issues. You cannot file on the same issues. The Office of Civil Rights will check with your state educational agency, and they will dismiss a civil rights complaint if the same issues are filed with the state.
Okay, perfect. What have been the things that you have filed that have not been successful, and maybe like in your early learning years? I know for me, I was like, oh, evaluation, eligibility. The OCR is not interested in that.
Well, they are interested in that. If you request an evaluation and the district either ignores your request, whether it's for a 504 or for an IEP, that's a slam dunk complaint. And that one's worth compensatory, because depending on the time that has gone on from when you submitted that written request to when when your complaint is opened or your school district actually does something, that's worth tutoring. It's worth speech and language, whatever the child's needs are. It is worth compensatory instruction or services.
Right. And then how long would that? So parents, we help them, write a very simple request for evaluation. And of course they're like, can we do a phone call? And the school district, who they know, talks them into just give them a little more time, and we're going to keep an eye on them. So I think that's against the law to keep your eye on anybody, but how long do they have to wait to be? They didn't tell them no, they didn't tell them yes at a PWN. They just called them in and said, keep an eye on it. So would that be agreeing with the school?
First, I tell people, stay off the phone. You want written records.
Yeah.
You
Yes.
want emails. And if your district, because some of them can be very smart and very sneaky, and they will call a parent. So a special ed administrator or a building principal, a social worker will call a parent to talk about a request. I tell parents, do not answer that call. Send an email and say, hi, I got your message and I'm having a really busy day. Can you please email me your question or concern? You want a written record. Because it's harder to file successful complaints based on a phone call.
Okay. And what about, I sent a letter to Elm Elementary School and I file a complaint, 6 weeks later, and they said, oh, we didn't get the email. And I always have people include everybody and all of their relatives on the email. I mean, just everybody. Nobody, there's a condition I call radio silence. We make parents crazy. How long should they wait?
There's a record of emails. So they can try to say they didn't get an email, but if it didn't kick back to you, they got that email. The Office of Civil Rights will open a complaint based on emails that are ignored requesting evaluations.
Okay.
I have found that some state educational agencies are not as likely to do that, even though they should. So I just tell everybody, just do a written request, put it on any kind of Word document. You don't even have to word process it. You can do it with pen or pencil or crayon, but put it on some kind of document, sign and date it. And then whatever your state regulations timelines are, because that's different in different states. It's crazy in Florida. In my state, if a parent requests an evaluation for an IEP, a district has 10 school days to obtain that parent's consent, and to have a parent, a parent has to sign the consent. If a parent doesn't sign, that's different, but the district has 10 school days. If they ignore that, I had a parent that called me today and said that she requested an evaluation last October. They obtained her consent in November, which was already out of compliance. They still haven't held the IEP. And now it's scheduled for the middle of April. And that is a civil rights complaint waiting to be filed. They've been denying this kid FAPE, and she had already been retained once.
Right.
So families that don't understand that you don't retain outside of kindergarten, it's a really, really big problem. And children are the ones that suffer.
Right. So I was telling somebody the other day, I had a civil rights complaint this after you learned me. You didn't even know I don't even listen to podcasts. That was the best 27-minute podcast of my life. And I filed 3 of them back to back in a school district. I won't tell you what school district it is, but it's corrupt independent school district. I know that doesn't clarify it for you. But I'm telling you, we're not best friends and we're not going out shopping, but there is a new respect for myself and a new response. It was a total shift. And I had somebody tell me, you didn't really file with the federal government, right? And it is a different response. It just is, because it's not the good old boy system.
You know, it's always funny to me how intimidated people are by the Federal Office for Civil Rights. We, the people, are civil rights. I mean, it's our government. And there's no reason to ever be intimidated by the Federal Office for Civil Rights, because those laws are here to protect all of us. And they can't be protected if we don't enforce them, which is why I wish people would, I always say, vote for civil rights when you're voting at the federal level. Do you vote for candidates that care about civil rights? Because if enough of them cared about it, we would finally see some federal funding for Section 504.
Right. I had a friend tell me one time, I said, is there any funding? She was ahead of 504 for a huge district. She goes, no, we don't get money for not violating your civil rights. And you would think it'd be just the opposite. Somebody in the chat said, what about an ADA complaint for dyslexia?
I'd have to know more about what that complaint is. That's too broad.
Okay.
Dyslexia, just even referring to anything having to do with dyslexia is pretty broad.
Okay.
You can have a 504 plan with dyslexia.
Right. So
you may not get an IEP, but you can have a 504.
Right. Somebody asked if a school cannot provide data on accommodation implementation, and they never can. Does that mean a parent can file an OCR complaint?
Well, you have to suspect that they're not implementing one or more of those accommodations. You can't just file it thinking they're not, because they don't have a data log. Districts that get civil rights complaints collect data. It's one of the better parts of filing one, is there is a new level of accountability, because they really don't want to go through this more than once.
And so when the investigator is, and I'm an assumer, it's just, they're just talking to the school district attorney. Are they talking to the volleyball coach? Are they talking to the bus driver? Or is it just the school district?
You don't know who they talk to. They can talk to anyone that is potentially involved in the discrimination.
Okay.
So you really, as the parent, as the person, whether I'm filing, you're filing, or a parent is filing, you don't know who they're talking to. I saw somebody say, what happens if you're past your 180 days and there are violations? Then you are left with either a special education state complaint, or you're left with a due process administrative complaint, which is what we call a hearable complaint, which are better in some states than others. In my state, there are no low cost or pro bono attorneys. And for me, that would be the unauthorized practice of law. So I can't help a family with a due process complaint outside of the very first step, which is a resolution hearing that has to happen within the first 14 days. Other than that, the parents need an attorney. So due process is very hard in states like mine.
Right. I mean, when we were talking before, which I was stunned, you said that Michigan does not have a single private special ed school. Can you tell us about that?
Michigan only has one mediocre school for kids with learning disabilities, Eaton, and it is truly mediocre. I mean, it doesn't drive public schools. In states that have good private schools for kids with learning disabilities, they're really good because they're largely funded by public schools. And that doesn't happen in Michigan. Michigan doesn't have a private school for children that have autism, not anywhere in our state. We have only the one school for children with learning disabilities. And as economics have suffered more and more in Michigan, they take a broader base of kids. And it's a one-size-fits-all approach to teaching, which definitely doesn't work for kids with learning disabilities. No, Michigan is very, very unique. Our state rules don't mention private schools. And I challenged that with the Office of Special Ed at the US Department of Ed years ago. And they said, well, it's in IDEA, so it technically doesn't have to be in your state rules. But the proof of the pudding is you just don't see real private placements in Michigan. They're done through private agreements that nobody knows about.
Because they're sealed.
They're sealed, and there are not that many of them.
Right. And that's what, that's what your son received. Is that correct?
I was reading a comment from someone.
Oh, but your son received, that was the result of his due process.
My son, we prevailed and we set a precedent for Andrew that is, while it's a state precedent, it is used in some other states. We were the first ruling to find that the least restrictive environment for a child was a one-on-one program with all private teachers and private therapists and adaptive PE teacher. That had not been done before. If we had had to go through federal court and prevailed, that would have been a federal precedent. We were headed to federal court until I uncovered really dirty laundry in my school district's closet that led to one state complaint that cost my district $484,000 in state aid.
Wow. Wow.
And a superintendent was retired.
I help people retire all the time.
I have actually been responsible for special ed directors being retired.
Yes.
I'm perfectly happy retiring certain special ed.
And I'm happy to do that. Yeah. I had somebody, a horrible special education director, and somebody said to somebody else, you know, she really is a nice person. She's not. You're violating a child's rights. You're not a nice person. Somebody said, when does the 180-day count start? Is it the first day of the violation or the last date you know of?
The last date you know of. You can go back 180 days.
Right. And when you file, it actually comes up. So you don't have to calculate it. Like,
no, you don't have to calculate. I do this often enough that I can tell you right now that if you were filing a complaint today, you could go back to August 25th.
Yes, we live by those dates, don't we? Okay, if your due process is, let's see, your due process is over, decision given, can you now file a complaint? Would it just have to be involving something not in your due process case?
Correct, because you can file. So for example, I have a terrible situation for a family in northern Michigan in a county and that doesn't have one speech clinician or assistive technology consultant trained to do an augmentative and alternative communication evaluation, AAC, not one in the whole county. They don't have an autism program in the whole county. And this is a student in middle school who is almost nonverbal. So we filed 2 civil rights complaints that were both open and they were done very closely together for different reasons. And right now we've been working on a resolution agreement. But I also filed a systemic special education state complaint against the county and the school district involved for violating the rights of all the kids who need an AAC evaluation or need consideration of an autism program. I actually did the interview yesterday with our Michigan Department of No Education.
And love that you say that, Michigan Department of No Education.
Well, and the comical part is that when the parent asked for this AAC evaluation and communication evaluation and occupational therapy evaluation, and we held a meeting to review all the existing evaluation data, and the director of special ed said, we don't have anybody to do an AAC eval, you'll have to get it on your own. I said, what are you talking about? I said, guess what? You put that on the notice page.
Yeah.
So,
and did they?
So she, that afternoon, she emailed and said, I have edited the notice page. I spoke to the superintendent. It gets better. And the superintendent agreed to pay for a portion of the evaluation.
Oh, that's so nice.
Here is a list of 2 clinicians you can call. You'll need a physician referral. One of the 2 doesn't have anybody on staff to do AAC. So that left one potential clinic to do this evaluation. And with them, they don't even have an opening until May. But then what happened? I filed the state complaint. And the day after they got the state complaint, all of a sudden the parent got a longer list of clinics and the superintendent saying, and we will pay in full.
Shocking.
But it's still, they still had on their list the one clinic, Central Michigan University, that has nobody on staff.
But you can call them.
You can call them, but they have nobody on staff.
Yeah.
And in addition, they're still making it the parent's responsibility to drive 2 hours to Sparrow in Lansing and to arrange and take a day off work. They could have reached out, and this was part of my state complaint, the neighboring county not only has an autism program, they have clinicians trained to conduct AAC evaluations. And I have emails with the superintendent with him refusing and saying, no, we gave you a list of 2. You have to choose from that list. We will not reach out to Midland.
Wow. Wow.
So that
so
is a
good.
systemic complaint.
Yeah. So, I mean, I think that's so good. And you know, when we talk about state complaints, I think one of the things that we talked about before is I call them very efficient, right? 60 days, you're in and you're out. Whether I call it sort of that show 60 days to getting married, it either worked out or it didn't work out. What do parents need to have? Obviously due process and then OCR. What is it that needs to sit inside of a state complaint to really hit?
You mean to really hit a district?
No, just to really like to have an investigation opened up.
By the state or by the federal office for civil rights?
The state,
by
the
the
state
state?
complaint.
Oh, the state
I feel
will
like it's the
open.
most
The state will
underused.
open. It's their findings will be so ridiculously bad.
Okay.
You know, the final reports that come out of most of these state educational agencies are bad to terrible.
The bad to terrible. It's their first cousins. The bad to terrible.
They're really toxic first cousins. But you have to know why you're filing a state complaint. I filed my state complaint that this county and school district don't have anyone to do an AAC evaluation is a solid complaint. And if the Michigan Department of No Education, if they don't find the violations, I will send it to the U.S. Department of Ed Office of Special Education. I will ask the Office of Special Education one of my questions like I do, and it'll be another OSEP letter to Lipsitt in a year. And they will, you know, they have found Michigan in violation of IDA several times just from my going to the U.S. Department of Ed Office of Special Ed Programs. So people can't be afraid of doing that either. If your state educational agency is violating IDEA or violating their own state rules and regulations, people should be reaching out to the Office of Special Education Programs. You know, you reach out to them, find out who is what you call your Part B compliance monitor,
Right.
which is ages 3 to 21. Part C is birth to 3. Who is that person? And I never stop with that person. I want to know who the team leader is and, you know, who is the regional. So you want to go as high up as you can, because the Office of Special Education Programs, while they take a long time, you know, they have found states in violation. You can look at OSEP letters too, and in my case, it's OSEP letters to Lipsitt, and those letters can carry a lot of weight. I mean, they have, Michigan had to, in 2007, had to get rid of our notice page because it violated IDEA.
Wow.
They had to recreate our notice page. And that was my first OSEP letter to Lipsitt in 2007. And then in 2015, they violated the state and federal complaint procedures when they decided they didn't have to issue a final report to a parent. And I'm thinking, what planet do they live on? And that really rocked the world. That was a major investigation by the U.S. Department of Ed and OSEP letter to Lipsitt, and it overhauled complaint investigations. It didn't create the comp ed that I would like to see for kids, which is why civil rights complaints are so important. But it did overhaul how they investigate complaints and make some districts pretty miserable.
What would you, I mean, my world has expanded since sitting here for the last 2 years with the Ethernet cord. I have clients from coast to coast, and I'm always stunned at how proud they are of their violations. And I have a state, I won't tell you what letter it starts with, but it's in the alphabet. And they've told me on several occasions, because I'll say just simple things like, are you going to offer the parent a reconvene since we disagreed? And they said, no, we don't have to do that here if we don't want to. So it's just part of the federal.
And they don't.
And they don't.
They don't.
So would that be a state complaint?
the first thing that I would do if they won't, it's not a state, well, I take that back. States can investigate. I nailed Michigan on this too. My state for years did not investigate children that weren't found eligible. And you can challenge eligibility through the state complaint system. You can challenge placement. But there are times if they won't reconvene, one, you can ask for a new IPT meeting in writing, and they can send you prior written notice saying, we just held an IP, we're not going to hold another one. You can try formal mediation and see if they're willing to go to mediation. If they're willing to go, sometimes you can accomplish a lot. If they're not really willing or they push back, it's not worth it.
Right.
And then you need, and then it's a due process administrative hearing, which is always hard. I tell people, we prevailed in due process, and outside of my son's medical crises, it was the absolute worst experience of my life. I saw the darkest and ugliest side of people I trusted with my son.
Right. And that's what I tell people. I mean, it's just, when I have families in due process, I'm allowed to do that here in Texas. And when I'm sitting there, because everybody's watching their faces, and I'm people that they thought truly that they loved their child, they were caring for their child, and it couldn't be more wrong. Right. It's just like the heart of darkness. Right. And it's everywhere because we don't spend the money to train our staff. And I can't be mad at Cindy, who's been there for 28 years, and she doesn't even know what child find means. She doesn't even know. Doesn't know what an implementer is. They don't know anything because their school districts don't invest in training them.
Oh, they invest in training them. What's wrong? I mean, they train them on how not to implement the state and federal. Most of the training done in these districts is done by the lawyers that represent the school district.
Of course. Yeah.
And you want to talk about teaching them the wrong way to do it? That's what those lawyers do. If it's wrong, it's come out of the mouth of a school district lawyer or a special ed administrator. And I don't know how these people sleep at night. I've said they have to have been abused as children to do what they do to children, because I can't justify why they get up every day to do what they do and not try to provide meaningful educational benefit. Is there no pride left in any school district in America in how they educate children? In my state right now, where until June, a janitor, a bus driver, somebody working in a school cafeteria, office staff, a para can staff any K-12 class in my state. I mean, honors English, honors algebra, algebra 2, a class for children with vision impairments can be staffed by any of those people through June. Thank you, House Bill 4394. And I'm not finding that enough parents care, and I call it COVID fatigue. I'm not justifying it. I'm explaining it. I tell people all the time, when I explain something, I'm not justifying it. I'm explaining it. And there is a qualitative difference between the two, because I'm not saying this is right. I'm telling you this is what is right now. And I don't expect people to be as nutty as I am, or you might be, when it comes to how many hours we spend fighting every single day for decades. But everyone can make a phone call. Everyone can send an email. Everyone can know who's on their state board of ed or on their local school board. I mean, you vote those people in. And I find in Michigan, most people don't know who the state superintendent is. And he's a moron, Michael Rice, but he's the state superintendent. If people don't care enough to know who their children are spending 6.5 to 7 hours a day with, there's nothing I can do about creating caring. I can educate, I can scream from rooftops, I can scream until people want to put me on mute, and you can put me on mute. I won't stop talking. I mean, I will talk as long as I can talk. People have to decide, children and the institution of public education matter. And if public ed doesn't matter, children with disabilities don't matter at all.
No.
There's no hope at all for kids with special needs when public education stops mattering to people.
Absolutely. So here's a question, and I was in several states. Washington, they don't provide dyslexia. They know about it. I'm like, in Kentucky, we don't do adaptive PE. What? So,
well, people have to be careful with dyslexia. It's sort of like a 4-letter word.
Yes.
Dyslexia is not an area of eligibility in IDEA. The area of eligibility, if you have dyslexia, is basic reading and reading fluency. Dyslexia is written in IDEA, just like it's written in the Michigan administrative rules, and
Right.
you can write dyslexia in a present level of performance or present level of academic achievement and functional performance, but the
Correct.
eligibility is not dyslexia. The groups that fight just for the word dyslexia are really dangerous in America, because who cares what you call it if teachers aren't trained to provide evidence-based instruction? Districts don't have evidence-based instruction. I run into districts that are using what's called AARI, which is for reading comprehension, not for basic reading. If kids are not receiving the right kind of instruction, why is the word dyslexia so important? Why are people willing to die on a sword for the word dyslexia? I'm outraged by it.
Right.
We
I
have
tell
bad
parents,
dyslexia bills in Michigan.
I said, stop saying dyslexia. Yeah, I mean, absolutely ask for a comprehensive IQ test with all 7 or 8 Ds, depending who you are, and all of those things will tease out. But it's not sexy, and it's not reading comprehension, and it's not reading fluency, and we get stuck there, and then we get crumbs, and your kid's in 8th grade and still can't read.
And there are
Right.
different kinds of dyslexia. There's
Right.
dysadetic, there's dysphonetic. I mean, there isn't one flavor. And dyslexia is not in the DSM-5. When doctor-level psychologists evaluate, they don't diagnose dyslexia. They diagnose a learning disorder in the area of basic reading. I mean,
Right.
they don't diagnose dyslexia. People have just got to get past that, because it is not moving the ball forward. It's not pushing the teacher preparation, which is the greatest need in this country, is to change teacher preparation. General ed teachers need to change how they are taught to teach reading to children, because the best practices for kids with dyslexia, if that's what you want to call it, are good for all children.
Right. Mm-hmm.
So it's teacher preparation in America has to change. Until teacher preparation changes, outcomes will not improve.
Right. I'm going to ask you one more question. We're so thankful for your time. I have a family that the school, who is just lovely. The student is in dyslexia, has done what it's always done, absolutely nothing. And so I say to parents, the kiddos in junior high, at this point, we have to figure out what we're going to do with our time. Just leave her, in special ed reading. And the school district has said it is illegal. It's a denial of faith for them to discontinue the general ed dyslexia. I'm like, what are you talking about? It's not even you can deny a related service. No, we've gotten guidance. If I have to hear that one more time. Why do you have to get guidance? Why don't you know what the law is?
Well, you have to ask them to provide you with the written rules, regulations, or policies that were approved by the school district's school board or by the superintendent, because it does not exist. I have a charter school that a family has filed 4 civil rights complaints for 3 kids. The one we can't file on is there's a little boy who it runs in the family. This little boy absolutely has real dyslexia. And the charter, to its credit, has 2 teachers that are trained in the Barton reading system, which if you provide that with fidelity, you're going to see marked improvement in a child's basic reading. They provide it to the 5th grade sister. They won't provide it to this little boy in kindergarten, and said that's based on Wilson reading, not Wilson, Barton. I called Barton and got an email from Barton saying, this is not part of we don't have criteria for how young a child can start to receive our instruction. I mean, the things that these schools will make up to not provide instruction, when what does it come down to? They don't have enough staff. So if they only have 2 teachers that are trained and they don't have enough staff, that's a real problem.
Yeah. I like that. I mean, I hear in 2nd grade and 3rd grade, we can start dyslexia. I'm like, I'm pretty sure we start talking to children the day they're born, or maybe we should just wait till 3rd grade.
Well, or do they all forget that you're learning to read, and in 3rd grade, you're reading to learn? That by 3rd grade, you're supposed to be a reader? Karen, you can't make up what we hear. I mean,
it doesn't sound real. It doesn't sound.
You cannot make it up. It is the worst of times.
Yeah, so that for that family where they're going to demand that they keep their daughter hostage in this stupid, awful, worthless gen ed, would that be a state written complaint?
So for this family, they requested a special education evaluation.
The students in special education just became identified. They had this goofy general ed dyslexia. It's never done anything. And so I tell parents at this time, let's just deboard. She's about to drive a car. I mean, she's in junior high. She doesn't need to be working on phonetic awareness. And they're like, no, the law says we have to finish the program. It doesn't say anywhere you have to finish a general ed. It doesn't say that. And if we don't finish it, it's denying her faith. And we can't be a part of that. So
that could be an interesting civil rights complaint. I have to take a sip of something.
Yeah, they're demanding, and it was on the heels of, the parent actually invoked their rights, right? And so
what I would file that on is denying the student access to general ed curriculum. If that student is being denied access to general ed curriculum because of the time receiving that reading instruction, I would file that complaint on denying access to instruction.
Okay, perfect. You are so stinking amazing. Yeah. Oh, and they also said if they take her out of dyslexia, they'll take all of her special ed goals away. That sounds fair, doesn't it?
Well, except that one's too much fun. We filed a complaint on that one with the charter I just mentioned, because special education can't be delivered by a general ed teacher.
Oh, it can't?
No, it cannot.
Are you sure? What about some parts of Texas?
Oh no, specialized instruction.
Yeah.
That is not general education.
It's not?
It is
Wow.
not. I ran into that in this charter. They have a general ed teacher providing Barton reading.
Yeah.
And they have goals and objectives. A general ed teacher can't provide the instruction on goals and objectives.
Yeah, that's why it's called specially designed instruction.
Special.
That word special. Or I had a teacher tell me the other day, oh, in our school, we just have people monitor it. I said, what does that mean? They're on IEPs, but we just check in with the case. What? Like you're picking up your lunch at Panera Bread? We just check in. No, I don't know what that means. Who's teaching them? They're doing good. Did you check?
You have to tear apart a progress report.
Yeah. Yeah. So good. Well, thank you so much, Marcie. How can
people have questions that weren't answered and they email me? I'm happy to answer questions. Yes. It's why I get 500 emails a day.
And can you share with us your Facebook page?
So I have Marcie Lipsitt, Education Advocate on Facebook. I have the Michigan Alliance for Special Education. I have the Special Education Wall of Shame. And then
we start a Texas Special Education Wall of Shame.
I shut down some rules in Illinois a number of years ago because we drove 5,000 public comments from that page. So the Special Ed Wall of Shame is national. Michigan Alliance is pretty much about Michigan. My Education Advocate page is about everything and everyone. And then I also have a website, marcielipsitt.com, and it's MarcieLipsitt. And my email address is marcielipsitt@outlook.com. And I do my best to answer every email.
Well, you have always been nothing but kind and generous and so full of information. And, we're just going to get louder and we're not going away. We're just going to put on some more lipstick and yell again. Because these kids, they need a voice.
They not only need, they deserve it. Again, think about the fact that not one child is ever asked before conception, you are going to be born to these parents. You're going to be born to these circumstances. Do you choose your assignment? No one. Right. No child ever chooses to be born. How do we not provide children with the tools and environment for that child to be everything that child can and wants to be? I tell parents, you can't give a child the want, but you can provide that child with every tool and environment.
Absolutely. So good. Well, thank you so much. You were so amazing. I'm sure we'll have you back on again because I'm going to get 5,000 questions. But if you guys need anything, you can always reach out to us at Admin Special Education Academy. And remember, when we get it right for the child, we get it right for everybody. We'll see you guys in the next training.